Tonight, testimony back on track with talk about Karen Read's taillight.
What happens when you impact an arm with a Lexus taillight at various speeds?
A crash reconstruction expert shares his findings.
It's inconsistent with striking an arm.
Plus, money talks. We take a closer look at the bill taxpayers will have to pay once this trial is over. And we're getting perspective from police after 2 officers took the stand this week. Canton Confidential, the Karen Read murder trial, starts right now.
Testimony today from an accident reconstructionist at ARCCA. This could very well be the most critical piece of the defense's case. Good evening, everyone. I'm Glenn Jones. JC has the night off. Testimony from the engineering firm's crash experts has been highly contentious in this trial. The firm was first hired by the FBI as part of a now closed federal investigation into how local police handled the case. But since then, ARCCA has been communicating with the defense, and that put them at the center of feisty pretrial hearings. Melanie Mendez is outside the courthouse with more on the testimony of Dr. Daniel Wolf. This was highly anticipated, Mel.
It was, Glenn. A lot of people were talking about these ARCCA witnesses coming in to be the potential star witnesses for the defense team. Well, here's the thing. In the first trial, these ARCCA witnesses took the stand and very clearly presented their data and their methods, saying, in their opinion, there was no way that John O'Keefe's injuries were consistent with having been hit by Karen Read's vehicle. Now, the prosecution fought tooth and nail to prevent these ARCCA witnesses from ever making the stand in this second trial. Well, they were unsuccessful in that bid. The ARCCA witnesses, the first one was back, and the science has not changed. Take a look.
Okay.
The objection sustained.
Yeah.
That's sustained too.
Yeah.
That's sustained. That's sustained too.
Yeah.
Ask it differently. That's sustained.
The long disputed status of the witness made clear by the dizzying number of objections by the Commonwealth while Dr. Daniel Wolf was on the stand. Almost as numerous as the objections were the visual displays for the jurors. In video after video of accident recreations, Wolf showed their testing methods.
We applied this same linear impactor to be able to project, if you will, or accelerate the taillight at a known speed into the ATD arm.
Showing what happens when a taillight collides with a dummy arm at various speeds, saying the damage to the taillight was inconsistent with the damage to Karen Read's SUV and inconsistent with the damage to John O'Keefe's clothing.
In any of the testing that you did you ever see taillight pieces cut, puncture, or fray the sleeve of that hoodie?
No.
Often displaying side-by-side images of the actual damage and damage that resulted from their testing. Here they are talking about testing done at 24 miles per hour, the same speed the prosecution is alleging Read was going in reverse when the SUV hit John.
Well, we accelerated that vehicle into the arm at 24 miles an hour.
Were you able to reach any opinions or conclusions as to whether the damage to the subject taillight is consistent with striking an arm at 24 miles per hour?
Based upon the test results, it's inconsistent with striking an arm.
After each test showing the damage to the taillight, the arm, and the sweatshirt.
It's inconsistent. It was inconsistent. It was inconsistent.
The doctor was asked about the so-called blue paint test done by the prosecution's witness and about its efficacy.
Doing this at 2 miles an hour doesn't tell you anything about, well, what happens at 10? What happens at 15? What happens at 20?
And what he says Welcher didn't do.
I'm not aware of any impact testing that he did. No.
Under cross, Hank Brennan immediately going after his credibility, then his prior communications with the defense.
Is there any reason why you deleted all of your text communications with the defense?
I routinely delete them after that communication is over with.
And potential bias.
You were communicating with the defense and attempting the best you could to assist their cause, weren't you?
I wouldn't characterize it that way.
It got heated a number of times.
I feel like I've answered it the best I can, Your Honor.
Okay, next question.
You don't like that question?
Sustained. Strike. Jurors disregard.
On redirect, Jackson went back to the science, asking again if the injuries to John O'Keefe's arm could have been caused by shards of taillight.
They would somehow have to accelerate with more speed to catch up and go beyond the arm, essentially.
Is that physically possible?
No.
All right, Glenn, now the jury will be back on Monday. First thing Monday morning, they're expected to have full days of testimony Monday, Tuesday, and Wednesday if need be. Back to you.
We'll see you back at your post next week, Melody. Thank you. We'll get to our trusted legal analyst in a moment, but we want to start with the three of us, lay people who are trying to get through all this scientific testimony just like the jury is required to do. Welcome back to Ronald Estanislao, a juror from the first trial, and our courtroom insider, Sue O'Connell. On the stand today was Dr. Daniel Wolf, the director of accident reconstruction at ARCCA. Not only did he show us video of dozens of tests, but he also brought a full taillight assembly with quarter panel and lift gate to the witness stand. So let's talk about this direct examination. Ronald, a lot more visual aids this time around than when Dr. Wolf was on the stand the first time. Does it help in terms of following along with the science? And if so, is there anything in particular you think would be helpful to this jury based on what he showed us today?
I believe that it's so much more helpful to have the tangible pieces to show, and all of the presentations that he showed clearly indicated more of what could have happened during that time frame. So
we know the tests were conducted more recently, so you didn't have access to that at the first trial. But the taillight assembly, those sort of props could have been used. Would they have been helpful?
Yes, definitely all those props are anything other than what they just did, which was just testimony during the first trial.
And Glenn, Jackson knocked on it.
Yes, I remember hearing that.
See how loud it was before the judge said, give it back.
All right, so there was a lot of physics and math presented during this, Sue. How was the jury following along based on your vantage point?
So I think they've heard about the scientific method now from a number of experts.
They could pass the physics test.
I think they could, and we keep talking, both lawyers, both Brennan and Alessi and Jackson all keep talking about it on a 6th grade level. They keep saying, middle school level, let's try and communicate it. And I think, I have to say that I think this was the best presentation of science that we have seen in this entire trial thus far. It was clean. I think Trooper Garino's presentation of the text messages and his presentation was also very clean, but this was really well done. And Dr. Wolf's explanation of the equations and how they worked, he did it in a very conversational way. I don't know about these things, and I think I even understood. So I think there was a success on that level.
So, Ronald, then let's compare the testimony of Dr. Wolf to the prosecution's expert witness, Dr. Welcher. How did those two experts compare in your eyes?
So from a science background, it seems like there was more of methodology that was given by Dr. Wolf in comparison to that of Dr. Welcher. So Dr. Welcher did give his testimony and gave information, but it didn't seem like he didn't show how he got to the data and the conclusions necessarily.
And you think that's something that Dr. Wolf did well?
Yes.
Okay. So, Sue, maybe the prosecution really has a problem here, because I know as lay people, when we look at those injuries on John O'Keefe's arms, we don't think pedestrian strike. And what ARCCA is saying to us is, actually, it's not a pedestrian strike. For some jurors, isn't that going to be the end of the story?
Yes, but on the other hand, we also had the jurors sitting watching numerous times a car crashing into an arm and a car crashing into a dummy. So if they hadn't been able to visualize how it might have happened, even though the point was to show how fast the car would have had to be going to get this damage, it was to exclude the damage to the vehicle as evidence that says she did it. Driving the car did it. It also now gave an actual image to the jurors in their mind of how it could have happened, which was not the intent of the defense, right? And at the same time, we saw an image of the dummy. I don't want to call it a crash test dummy because I know that's a technical term.
You're right.
Spin around.
That's right. Rotate.
And rotate, and the shoe, how it would have come off. Of course, this is right after Hank Brennan said the dummies aren't real people, so don't expect them to act like real people. But it actually pirouetted, which is what they said in the last, it was a question in the last trial that Alan Jackson had. So you're saying it just pirouetted around? Did John just pirouetted around? And we actually saw that today happen. So obviously the jurors may not know that is, but to what Ron said a moment ago, where now we can see how it happened, it's a dangerous place to be. So they have to remember that the defense was trying to disqualify the evidence by showing you things that had to happen in order to get to that point, but these didn't happen, they say.
What an interesting point. Okay, Ronald, we do have a viewer question that we want to ask you about. You're the perfect person to ask. It comes from a couple in Quincy. When a question is asked and answered, and then the judge strikes it from the record, how does that affect the jury? They can't unhear the information. That happened a lot in your trial. How did you deal with that?
So for me, I would cross whatever the note I had taken, I would cross it out. And it would be an X indicating to me not to take that into consideration. Unfortunately, as Morgietta has already pointed out and Sue has pointed out, we've already heard it. So once it's heard, it's kind of hard to really strike it. But during deliberation, if it's an X to me, I did not take it into consideration.
Can I just ask, do you think that someone's getting in trouble when they have to strike something? Like when the judge says strike that, do you think that's
is it a
punishment?
reprimand?
Yeah.
Right off the bat, to me at that time is a reprimand. Like, especially if they say strike that, as opposed to just sustain. Sustain is one thing, but as soon as they say strike that, that's like.
I can't unhear anything. I just want you all to know. Also, Ronald, as a former jury, we've been relying on your shock radar with just about eyewitnesses. There's a shock moment. For Dr. Wolf, I guess that was supposed to be the signal chat. For Shannon Burgess, it was the educational credentials. But with a moment like that, for every single witness, does the shock begin to wear off for you?
Yeah, so as soon as there's something there, you suddenly go, oh, okay. Hold on, I need to look at the whole thing. I can't just look at one thing. I need to look at the whole picture and take everything into consideration.
Okay. We're going to have Morgietta Durissier join the conversation shortly, but let's just listen to this real quick.
With regard to the scientific method, did you see whether or not Dr. Welcher followed this scientific method as you're explaining it to the jury?
Yes. Sustained.
What did you note, or what opinions or conclusions did you come to about the scientific method, if any, that Dr. Welcher did or did not undertake?
Sustained.
Did he undertake the scientific method as you know it?
Objection. Right, so that's sustained.
As promised, joining the conversation now is Morgietta Durissier, our defense attorney and legal analyst. In that exchange, Morgietta, the prosecution really wanted to prevent Dr. Wolf from critiquing the work of Dr. Welcher. I just want to know, broadly speaking, do you think Special Prosecutor Brennan was able to score any points with this witness, whether it was, as I mentioned earlier, the signal chat or something else?
So I said this to a number of my colleagues, especially earlier this afternoon, that I feel like he did a great job in presentation. You have to remember, Hank Brennan is a defense attorney, so this is his wheelhouse. However, I feel like the presentation was a net zero, meaning he got some information out, but it resulted in nothing that really moved the needle in his case. Remember, this is the defense's case in chief. This is not the prosecution's case in chief. So his job to discredit witnesses is what he's supposed to do in cross-examination, but he's not supposed to disprove the defense's case. That's not his job. And I think that's what he was aiming for, and that's why I called it a net zero.
You agree with that assessment, Sue, it being in the courtroom?
Yeah, I mean, absolutely. I do. I was saying earlier to Morgietta, there was this big moment when they were talking about the difference of the weight of John O'Keefe's arm versus the dummy arm that they had, and he was using the percentage of all the calculations must be wrong if you didn't do that. And then Alan Jackson gets up and says, we have no idea how much John O'Keefe's arm weighs. That was just an estimate. And I could actually see the jurors go, oh, okay, never mind. So it was a net zero.
Okay. After today's testimony, we know a little bit more about the money being spent for crash reconstruction experts on both sides, and there is a big difference. Take a look. Massachusetts taxpayers will be on the hook to pay well over $300,000 for Aperture's experts, while the defense is paying $50,000 to ARCCA. Both sides probably have logistical expenses, and of course the FBI presumably billed ARCCA for work that seems to now be benefiting the defense. So the jury has this information through testimony. So Ronald, I guess starting with you, is this something that you weighed? Did you even have any of that information during the first trial?
No, we didn't have any of that.
Would it have mattered?
So looking back at it, I don't think it would have mattered. I think all we would have cared about, at least based on our charge, is to look at the evidence that was presented to us.
Morgietta, the attorneys have been careful to get this information into evidence. What do they hope to convey to the jury about this information?
So they're trying to create a bias here, right? And so the implication is the more you pay someone, the more they're going to favor what you want them to say. But I don't think in this case where you have 60, 70 plus witnesses, it really matters at this point, right? Because it's really about the credibility of what the witness is saying, how they're saying it. We've seen great witnesses and we've seen some really horrible witnesses. So I feel like the expenditures are kind of going over people's head. I think if it was a smaller trial, you could see where that bias is really being pushed in, but I don't see it really mattering in this case, as Ronald said.
Okay. Ronald and Stanislaw, thank you very much for joining us again. Sue and Morgietta, you will be sticking with us. Don't go anywhere. Before we go to break, we want to take a moment to remember John O'Keefe, the victim in this case. The Boston police officer and Braintree native became the legal guardian of his niece and nephew after their children lost both of their parents to illness. You're watching Canton Confidential, the Karen Read murder trial.
Don't miss any of the Karen Read murder trial. Get the full recap of what happened in court, expert analysis, and what we could see next. This is coverage you won't see anywhere else. Canton Confidential, weeknights at 7 on NBC 10 Boston.
I'm telling you, I did not see anything. Factually, I've been provided evidence by a timeline that it is not correct.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
That was just a snippet of some of the testimony from Boston police officer Kelly Dever and Dighton Police Sergeant Nicholas Barros earlier this week. And back with us now is Morgietta and Sue, and we're joined as well by retired Newton Police Chief John Carmichael. Welcome back to Canton Confidential. It's great to have you. All right, so we just saw two different people there, two different professionals with two very different temperaments on the witness stand. Officer Dever said in her testimony that she had a meeting with Boston Police Commissioner Michael Cox before her testimony, and she says he told her to do the right thing. I've just been so anxious to ask you, have you ever had one of your officers in ahead of testimony to counsel them in some way before they took the stand?
Yeah. No, not for testimony, but certainly for a lot of other different things. And I think that this has just been a unique case that has been out there in the media so prevalently that I think that, the commissioner probably wanted to ease her mind a little bit and bring her in and maybe give her a pep talk. And, that the whole issue of do the right thing is, go in there and do what you have to do, tell the truth, and everything will be fine. I think that's just great show of leadership where he's supporting one of his officers during a situation that's just so much in the media that I think it's a good thing.
If an officer has to report a fellow officer for misconduct or there's suspicion of misconduct, does that officer's superiors have a responsibility to protect that officer from harassment or intimidation within the department?
Yes, they do. And actually, now that the post standards, the peace officer standards and training, the new law that went into effect a couple of years ago, it actually has built into that law issues about retaliation. So anytime a police officer reports misconduct to their superiors, there can be no retaliation. So
that insight is very helpful. Yeah. The public's perceptions about police has taken a lot of heat as a result of this trial. Here's a couple of clips from testimony this week that might create even more unease with the public.
Have you ever heard of something called the blue wall of silence?
Objection.
Sustained.
Do you think it's important for police officers to protect one another in the field and out?
Objection.
Sustained.
Sir, did you follow protocol that night?
I did not.
Why not?
Knowing the Albert family, knowing that there was a first responder, I gave them respect and opted not to follow procedures.
So you and I have talked a little bit about
we're off the record.
Yes, we talk a little bit, really. No, just about the way that this case maybe exposes what seems to be a different set of rules for police officers than the rules that everybody else has to abide by. The Brian Albert situation, what Lucky just explained. We could go on and on. Is the damage exposed in this case repairable for law enforcement across the Commonwealth?
Yeah, I mean, there is. There's different problems and different levels of problems. I don't know if you guys are old enough to remember the cartoon of the police officer walking by taking the apple off the stand. It was an old Depression era that the officer got to get the apple for free. And I think it's a big difference between calling your second cousin to get a ticket fixed versus, not following proper procedure on an investigation. So you have to look at the totality of this. I was accidentally on a live stream this morning. Someone, came up to me and interviewed me, and I said, listen, we all want police from our community that we know that will help us. We just don't want it to go over the line. So, worrying about, the Albertine maybe having a car out there and getting some preference, not a big deal. Following proper procedure, though, I think is a big deal.
Morgietta, we only have a few seconds left, but you have been critical of the way police handled this investigation. How do you expect that part of it to be instructed to the jury? How much can they weigh that in their decision?
So they should take that decision very heavily in their deliberation. And we've said it before, it's called a vote in defense. And it's not to discredit police officers in general, but it's really talking about the investigation of a murder of an individual. And you have to put that in the forefront when you're deciding all of the evidence in the case, because that's what actually brings the case forward. So if you can't trust that, then how can you make a proper deliberation?
All right. Guys, we could talk for so much longer, but we're out of time, unfortunately. Chief, thanks for coming back to see us. We really enjoy having you here. Sue O'Connell, Morgietta Durissier. Thank you all. Remember to join us every weeknight at 7 on NBC 10 Boston. We'll have a full recap of the latest developments from court, as well as legal analysis. Plus, this week's episodes will be streaming on Peacock starting on Sunday, but you can see any episode right now by going to Peacock. You're watching Canton Confidential, the Karen Read murder trial.
Watch LaToya Edwards and Raul Martinez weekdays at 6 a.m. on NBC 10 Boston.